Welcome, and what a wonderful sight to see so many people in one room without a mask on. And now I see someone with a mask on, sorry, almost all without a mask. And it's a great pleasure that we're all gathered here together after 3 years of partly virtual, fully virtual, and now we're all fully live. So thank you very much for coming, thank you very much for your support. So welcome to the 17th lecture in this series. And my, doesn't time fly? Seems like only yesterday we started this off. I'd like to begin, of course, by thanking our hosts, Stevenson Harwood, for accommodating us and being very generous with their space and their hospitality. When the lecture was announced, you wouldn't be at all surprised, of course, but within 24 hours, we could have filled the Hong Kong Club up twice. So we had to move, and they very kindly offered these wonderful premises for us, and now we can get so many people here. And I think that's very nice of them, and I thank them very much. And of course, it's great credit to our lecturer that so many people want to hear him. I also like to thank the British Institute of International and Comparative Law, BICL to its friends, for being our sponsor. Unfortunately, the director, Spiros Maniatis, couldn't be here tonight, but in a classic case of double hatting, our lecturer happens to be the president of BICL. They are represented. As you know, the ones who come to this lecture frequently, I always like to say that this is a first. And there are two firsts tonight. The first is this is the first time we've had a past or serving President of the Supreme Court of the United Kingdom as our lecturer. And I think, or I'm sure, it's the only time we've had a lecturer with a former lecturer in the audience. And with Bill Blair, where are you, Bill? Bill somewhere. I know you were here because I've seen you already. And so it's nice to have you here too as well. So there's a nice continuity. David Neuberger, as you all know, has had a stellar career. He flirted with chemistry and finance, but obviously found them too exciting, and moved to the law. And he practiced in England from landlord and tenant chambers, and had a very good practice in the Chancery Division and in other areas, and was appointed to the Chancery Division of the High Court in 1996. He had to remain in the Chancery Division for 7 or 8 years before he was promoted to the Court of Appeal. But at that point, his career took an amazing trajectory. He was only in the Court of Appeal for a short time because 4 years later he was made a law lord. He was the youngest sitting law lord at that time. Now, being appointed a law lord is, for most people, the pinnacle of their legal career. Not so for our lecturer tonight, because after a very short time he did a Lord Denning and left the House of Lords and became Master of the Rolls, a post which he held with distinction until another career change when he became the second President of the United Kingdom Supreme Court. Now, in that position, as you know, he's handed down many substantial judgments. I think it's fair to say that if you're doing commercial law, there's hardly a case or an arbitration in which one of his decisions is not quoted, especially when it comes to construing contracts. He hit the headlines, of course, dealing with the Brexit case in the Supreme Court, which was an interesting time for us all. But at the age of 70, he had to retire because that then was the statutory age of senility for judges. Absolutely ridiculous, as you can see. And it's changed now. But he had to leave. And the loss to the judiciary was certainly the gain for arbitration, because since then he's been actively acting as arbitrator, and I'm very pleased to say that I've been sitting with him, as have others in this room, for most of the time. I think that he's been acting as arbitrator. And he brings to arbitration the same legal brilliance, mastery of the facts, and although he accuses himself of being a little bit judgy, I think that's unfair, and he really conducts cases with an amazing charm, and everything goes very smoothly. So it's with very great pleasure that I asked Lord Neuberger of Abbotsbury to deliver the 17th lecture in the series.
Whenever I hear a description of my career, I always think about being a law lord, because a large number of lawyers, even in the UK, didn't quite understand what a law lord was. And one of our friends, actually, who was not a lawyer, thought I'd become a warlord. Before I start, I'd just like to thank Neil. He came to see me when I was still in the Supreme Court to give me a bit of advice about my future career as an arbitrator, which he realised I was going to have, and I didn't at the time. And he, with Michael Prowse, selected me to preside in a rather fraught arbitration in Hong Kong, or based in Hong Kong, which was a very good educational basis for my career as an arbitrator, because I had two very experienced co-arbitrators who kept on telling me, you can't do that, or you should do this. And it was a case with a great deal of work to do and not to do. So I'm extremely grateful to Neil. It's 16 years, as he said, since the first annual Kaplan lecture. The first was given by Neil himself, and explained that the purpose of the lectures was to be more practical and more Hong Kong focused than other arbitration lecture series, such as the Goff lectures. The passage of those 16 years means that there have been a large number of topics covered in a series of diverse and interesting lectures. And that there's also, in that period, there's been an accumulation of relevant new experience and developments. This is particularly attributable to the continued growth in international arbitration, both in terms of traditional international commercial arbitrations and the more recent ISDS and BIT arbitrations. My aim today is to focus mainly on a number of practical topics, many of which have been covered in previous lectures. I'd like to concentrate on practical topics, in particular, partly because this is one of the aims of this lecture series, but it's also because as a common lawyer, I'm rather more at home with bottom-up case-related issues than with high-level, top-down philosophical questions, which provide more familiar subject matter to civil lawyers. Nonetheless, reflecting the lecture topics, I will touch on one or two broader topics, rather than which are important and relevant. Secondly, I want to cover a number of topics rather than one topic, particularly in these days of short electronic messages and consequent short attention spans. It seems to me that a 45-minute lecture on a single topic is a bit of a challenge. After 20 minutes, I think the audience starts to lose the will to live. And after about 30 minutes, the speaker does too. A talk is likely to be more interesting, or perhaps I flatter myself, less boring, if one covers a number of topics.
Sorry, Michael, your mic stopped.
My mic stopped, has it? Yes, it has. Okay.
You can swap with Neil. Swap with Neil.
It can get even more boring if you can't be heard. I also thought it might be worth looking back and considering in relation to certain topics which have been covered in previous lectures, what was said then and what could be said now. Before turning to the various topics, it's right to mention that whatever one is considering, the ultimate purpose of this lecture is to consider what improvements can be made to the current practice in international arbitration. Hence my reference to the Holy Grail, because the aim is to identify the procedural ingredients of a perfect arbitration. But I'm conscious of a certain irony in the choice of title, because of course the Holy Grail was never actually found, despite the best attempts of King Arthur and his knights. But I think that this unattainability is in fact apt. While like the Knights of the Round Table, we should be seeking perfection in arbitration, we have to accept that we will never achieve it. Perfection is rarely available to us humans. But also, different cases, different parties, different legal systems, different inclinations will favour different processes. But that again is like the Holy Grail, which could not only not be found, but if you read the literature, the writers couldn't even agree what it was. But let me move from medieval myth to arbitral actuality. The first stage of the arbitration voyage is the arbitration clause itself. I'm not sure how much time it's worth parties spending time worrying about the clause when drafting the contract, unless you know what sort of issue is going to arise, as you will not have much idea of what you or your client will want in the clause. Following Jim Spiegelman's lecture, I think it would clearly be sensible to make sure that the applicable law of the arbitration and of the clause itself are specified. In the case of connected contracts with arbitration clauses, the parties may be well advised to consider whether to provide specifically for consolidated arbitrations, and given uncertainty in some jurisdictions, it may also be right to consider how wide the scope of the clause should be. And it may be worth spelling out what, if any, input the parties should have in the appointment of the presiding arbitrator. In agreement with Neil Kaplan, I think that the parties should also consider whether the arbitration clause should include provisions which stipulate for a reasonable time limit for the award, a provision which limits disclosure or production, a provision which excludes or potentially includes punitive damages, provisions which define the applicable principles of confidentiality, and possibly a provision which provides that if the amount at stake is less than a specified sum, there will be a sole arbitrator and the award can contain no reasons, so that it's proportionate in cost and time. The next stage I want to consider is the start of the arbitration. These days in particular, when arbitration process has become pretty procedure-driven, when many arbitrations involve claims for very large sums indeed, and when there's often considerable domestic public interest in the outcome, the need for both parties to be represented by lawyers and counsel who are both competent and honest has never been greater. That may sound rather obvious, but it's underlined by a very recent judgment in the English Commercial Court, which no doubt a number of you will have seen, the Republic of Nigeria and Process Industrial, handed down less than 6 weeks ago. In that case, leading counsel and the solicitor acting for P&I were held to have acted indefensibly in receiving and retaining a succession of Nigeria's internal privileged documents and using them. And Nigeria's counsel gave what one might call idiosyncratic advice to his client, and at the hearing did not understand questions put to him by the tribunal, as the judge put it, not through any lack of clarity on the part of the tribunal. So one side was apparently represented by unprofessional counsel and the other by incompetent counsel. As a result of the indefensible action, and there was also bribery involved, after 30 days argument in the commercial court and some evidence, an award for over $6 billion made nearly 7 years earlier was set aside. As the judge, Mr. Justice Knowles, said, quite apart from the consequences for the parties, the matter touches the reputation of arbitration as a dispute resolution process. Slightly unfair on arbitration because the decision had previously been taken to the commercial court, where it had been, the decision of the tribunal had initially been upheld. Fortunately, the facts of Nigeria and Process Industrial are wholly exceptional, but the case is a salutary reminder of the importance of counsel being honest, which most of those of us involved in arbitration normally take for granted, which we're lucky enough to be able to do. If that ever ceases, public confidence in arbitration will be well and truly undermined. And the case also demonstrates how important it is that parties are represented by competent counsel. I turned from counsel to the tribunal. In his lecture, Neil Kaplan recommended a possible variation to the traditional way of selecting a three-person tribunal, namely that the parties appoint a neutral chair and then leave it to the chair to put together what he called a dream team based on the chair's knowledge of the case. This is an interesting idea and would render possible another idea that he promulgated, namely that as the hearing and the procedure progresses, only one member deals with a particular procedural issue and another member deals with another procedural issue, and then when it comes to the hearing, they distribute the technical and other issues between them. But as far as I'm aware, this innovative idea has not been taken up, at least to any significant extent, but maybe its time will come. In my 6 years as an arbitrator, I've been very favourably impressed by the independence and lack of partisanship of party-appointed arbitrators, whether in this jurisdiction or other jurisdictions. When presiding, I normally have to check the record if I want to see which of my co-arbitrators was appointed by which party, as it's quite unclear from the attitude they display to the parties and to the arguments. And in the rare case where a party-appointed arbitrator is partisan, I've noticed that it's normally actually counterproductive. The presider, if they are any good, quickly realizes if a co-arbitrator is biased, and then largely or wholly discounts that co-arbitrator's contributions. Once the arbitral panel is constituted, there are directions to be given and interlocutory steps to be taken. The extent to which the directions should be imposed by the tribunal or agreed by the parties is sometimes a matter of debate. There are those who say that arbitration is a consensual exercise and say the parties should be entitled to insist on the direction that they've agreed, whereas others say that experienced arbitrators know better than counsel, and so the tribunal view should prevail. In my experience, this is normally something of an academic debate, with reasonable counsel and sensible tribunal members, whether the first draft of the first procedural order is drafted by the tribunal or negotiated between counsel makes little difference as to the ultimate terms. During the period between the giving of directions and the evidentiary hearing, the potential for contrast between different arbitrations is striking. In some arbitrations, after giving agreed directions, the tribunal hears nothing from the parties other than being served with the pleadings as they are circulated, until the tribunal has sent the agreed timetable for the imminent evidentiary hearing. By contrast, in other arbitrations, like my first arbitration with Neil, the tribunal is bombarded almost weekly with requests for decisions on a plethora of procedural points which the parties cannot, or in some cases simply will not, agree. It's tempting to say that lawyers do their clients no favours by adopting an unduly belligerent approach to dispute resolution. In the first place, it leads to increased costs, both directly, as resolving each argument costs money, and indirectly, as unnecessary arguments add to the complexity, which in turn leads to increased costs. And secondly, a belligerent attitude risks alienating the tribunal. As a general proposition, I think that is generally correct, but I would be falling into the trap of forgetting what dispute resolution was like when I was at the coalface if I suggest that it is always right not to be belligerent. Like everything, it has its place. Turning to the directions which a tribunal may give, there is of course the familiar battle between common law pleadings and memorials. Where the issues have been identified, or perhaps where they can easily be identified, there is much to be said for memorials. But where the parties are unclear as to the other party's case, and particularly where the claimant is unclear about the respondent's case, memorials have obvious problems because the claimant in particular has to adopt a scattergun approach, unclear what the respondent's case precisely is. In her Kaplan lecture, Lucy Reed argued for shorter pleadings and memorials. She suggested that the parties should concentrate on quality rather than quantity in their submissions and adopt proper strategies that can guide the tribunal through their case, like a clear trail map guides a climber to the top of a mountain. I agree, although this sort of plea is often made and regularly appears to fall on deaf ears,
when made by an arbitration tribunal. A more robust approach would involve the tribunal limiting the number of pages right at the beginning for each party's case, whether on a pleading or a memorial. That gives rise to something of an obsession of mine. A page limit, which is very often imposed, for instance, on post-hearing briefs, requires one then to specify font size, margin width, and line spacing, which is both tedious and pedantic. Far better, I would have thought, simply to have a word count limit, which is far more difficult to cheat on, except I suppose if you hyphenate every word. And very easy to check with word count on the machine. Turning back to directions, the most notorious exercise which falls to be performed during the period between directions and the hearing is, of course, document production. Once one departs from a rule that there is no right to document production, or at the other extreme, that every party must disclose any conceivably relevant document, one is in difficulties. That's for two reasons. First, the volume of documents in this electronic age is potentially enormous. Secondly, interlocutory decisions, such as whether to order production, are often far harder than final decisions, as one does not know all the facts, and one has only sometimes a nodding acquaintance with the legal issues. And when the interlocutory decision concerns a document one has not even seen, the decisions can be even more challenging. The various attempts by the English courts to simplify disclosure, which throws up identical issues, have not been successful. In many cases, the parties' arguments on document production are of epic length, going to minute detail, which largely explains why mention of Redfern schedules results in groans from many arbitrators. In his lecture, Neil Kaplan suggested that arbitrators should adopt a far more active and hands-on approach when dealing with disputed and complex document production issues. If that means the tribunal should be prepared to adopt what accountants call a quick and dirty approach, I think it would probably require the parties' agreement, and as I say, could be dealt with in the draft, in the arbitration agreement. If it means that a tribunal should be more informed, then it's a little hard to see how that could be achieved without the arbitrators actually having sight of the documents. A plethora of documents, which often results either from the parties' agreement or from orders on Redfern schedules, leads to extra expense in terms of document requests, searching, bundling, submissions, and cross-examination. Charles Hollander, King's Counsel, in his work on documentary evidence, supported, and I quote, the view that electronic disclosure is more than any other factor responsible for the increase in the cost of litigation in recent years, and added that in recent years electronic disclosure has led to vast costs spent on disclosure. And the same, I think, may be true in some cases of document production in arbitration. Of course, there will be cases where detailed document production orders leads to discovery of a smoking gun. But I suspect the great majority of such cases, even when there's a smoking gun, would have been decided the same way and more cheaply without the documents to get produced. And in any event, in my experience, further down the arbitration road, apparently smoking guns frequently turn out not to be smoking or even guns. As Hollander also wrote, clients often overestimate the importance of disclosure and expect to see smoking guns that never materialize. Thus, the spending of disproportionate sums on disclosure is often client-driven, and consultants as well as lawyers are often keen to propose further and better searches, with the consequence that it has all got out of hand. In any event, I question whether the fact that in one or two cases document production has made a real difference justifies the pointless expenditure in countless other cases where it makes no difference. It is, I suggest, appropriate at least to consider this issue more clearly. There's obvious force in the point that the time-consuming and expensive operation of document production in every case cannot be justified simply because it produces justice in very few cases. not merely the likely value of document production may outweigh the cost and time involved, it's also that potential litigants and people involved in arbitration are put off going to arbitration because of the cost involved. And as mentioned, those costs are often increased substantially by document production. It may be attributable to my background, to which Neil briefly referred in science, but I must admit to being a bit puzzled by the fact that there's no attempt by arbitration professionals, by academics, or by the arbitration institutions to investigate the cost effectiveness of our procedure in arbitrations. It's fair to say that the same sort of comment can be made about litigation, where the public interest in effective procedures is even greater, but it does not alter the point that it has force in relation to arbitration. In particular, it seems to me there could be real interest in devising some scheme for establishing the value of document production, and it may be possible to conduct a survey of parties and tribunals after final awards, to inquire, for instance, as to the extent of documents ordered pursuant to document production requests, the amount of time spent on those documents, and the extent to which those documents made any difference to the outcome. Of course, the responses in each case may be inconsistent, impressionistic, or at times self-interested, but it would at least be worth trying, bearing the amount of money spent on this document production in arbitrations across the world every year. Another controversial issue and a difficult directions issue, which not infrequently arises, is whether or not to bifurcate, or in common law parlance, whether the tribunal should determine some preliminary issues. There are English cases where judges have warned that it can be a dangerously seductive cause, and so it can, as dividing up the case which goes all the way can easily give rise to more delay and more costs than if the more traditional course of a single hearing was adopted. But there are cases where it is a sensible option to adopt. It's not easy to give guidance on this, as so much depends on an individual case. In his lecture, Sir William Blair, who, as Neil has said, is here this evening, recommended what he called early determination applications for both the claim and defence in international financial disputes of high value, because he considered this could encourage conciliation at an early stage, as well as bringing forward any issues needed to preserve assets. So it's certainly worth considering, in particular in those sort of cases. I move on from interlocutory issues to the evidentiary hearing. And I have quite a lot to say about both factual witnesses and expert witnesses. So far as factual witnesses are concerned, there are three fundamental problems, which in stark summary terms are as follows. The first problem is that factual witnesses, they're called, are often unnecessary. The second is that they are generally unreliable. And the third problem is that arbitrators, like judges, are not very good at telling liars from truth-tellers. Turning first to necessity, many, in fact, probably most commercial arbitrations involve issues of contractual interpretation. And in most cases, oral factual evidence is at best questionable on such an issue. In a common law case, at least, one cannot take into account the parties' actual intentions and understanding as to what the contract meant or was to mean, nor can one take into account what was said in negotiations when interpreting a contract. Such evidence is strictly inadmissible in law, although it's only right to add that it's potentially admissible and can be crucial in those cases where one party is seeking rectification, but those cases are relatively rare. Although factual evidence is therefore mostly irrelevant in a dispute as to contractual interpretation, in many cases, in my experience, the tribunal has to listen to a number of factual witnesses. The excuse for such evidence is that while actual intentions and understanding and the negotiations are irrelevant, the surrounding circumstances, the so-called matrix of facts in which the contract was agreed, is relevant to its interpretation. That matrix includes in particular relevant facts known to both parties and relevant commercial realities at the time the contract was made. But the relevant factual matrix is normally obvious or anodyne, and even when it's not, it should be capable of being agreed between the parties without much difficulty. I suspect that client pressure plays a part in the parade of irrelevant witnesses which a tribunal sometimes sees, The desire to explain one's case is understandable, especially if the other side are also calling irrelevant witnesses. And at least in some cases, lawyers will not be popular with their clients if they stand in the way. And to be blunt, proofing and calling unnecessary witnesses may have some financial attraction for the party's lawyers. So far as reliability of witnesses is concerned, Tony Landau, KC, in his lecture, relying on legal principles and scientific evidence to show that witness memory is not reliable, said that it seems to be and may easily be manipulated. He made much of the way that proofing and witness statements distort or alter a witness's recollection, and also showed that the manner of presentation in court, the way that witnesses are required to give evidence in court, makes things even worse. I agree with that, but it seems to me that even without procedures imposed by our dispute resolution rules ahead of and during a hearing, a witness's evidence would be unreliable. The problem was graphically described in England by Mr. Justice Leggett, now Lord Leggett, in the 2013 Guessman case, where he discussed the unreliability of human memory, explaining that he did not believe that the legal system has sufficiently absorbed the lessons of a century of psychological research into the nature of memory and the unreliability of eyewitness testimony. He added that we are mistaken in our beliefs, one, that the stronger and more vivid is our feeling or experience of recollection, the more likely it is to be accurate, wrong. And secondly, that the more confident another person is in their recollection, the more likely their recollection is to be accurate, wrong. He also pointed out that memory is particularly vulnerable to alteration when a person is presented with new information or suggestions. And echoing Tony Landau, Justice Leggett said that the process of civil litigation itself subjects the memories of witnesses to powerful biases, so that considerable interference with memory is also introduced in civil litigation by the procedure of preparing for trial. Accordingly, he concluded, the best approach for a judge is to adopt in the trial of a commercial case is, in my view, to place little, if any, reliance at all on witnesses' recollection of what was said in meetings and conversations, and to base factual findings on inferences drawn from the documentary evidence and from known or probable facts. He nonetheless accepted that oral evidence could be of some possible use, although adding that its utility is often disproportionate to its length. It's just as well he accepted that oral evidence has some value, as otherwise presumably most criminal trials couldn't proceed. In many cases, oral evidence is the only evidence there is, even in small civil cases. But I think, while his comments have been greeted with restrained enthusiasm by the Court of Appeal, there is considerable force in what he says. It highlights a third problem with factual witnesses. We humans, including judges and arbitrators, are poor assessors of witnesses. A 2005 study involves observers watching live witnesses and others watching witnesses on video, in each case being asked to assess whether the witnesses were telling the truth or not. The accuracy rate for both groups was just about 50%. You might as well toss a coin, and it would be cheaper. Further, there was significant negative correlation between accuracy and confidence. In other words, the observers who were most confident when assessing somebody's truthfulness were least likely to be right. This is confirmed by other research, including a paper by Daniel Kahneman of Thinking Fast and Thinking Slow fame, who reports that confidence is a highly misleading guide to accuracy in decision making. And a 2008 paper summarized the results of 25 studies considering the accuracy of professional investigators' attempts to justify the veracity of statements. And they were successful in identifying truth in 56% of the cases, a bit better. There's thus force in the view expressed by one researcher who wrote that the legal systems employed in common law countries are based in part on a fundamentally flawed principle, that the human beings who are charged with the task of discriminating truthful from deceptive witnesses are able to do so accurately and consistently.
To put the point another way, it's easy to confuse a good witness with good testimony. A good witness is a person who appears impressive to the tribunal when giving evidence, but that does not mean that the testimony they give is any more reliable than if the witness had been a pretty unimpressive one. The certainty which is so suspect when it is felt by a judge or arbitrator when assessing the testimony of a witness is equally suspect when it's expressed by the witness giving their recollection of events, and yet many tribunals are impressed by a confident witness. That is dangerous. The same point can be made with equal force about verbally articulate or personally engaging witnesses. And judges and arbitrators can be affected by other influences when assessing witnesses' testimony. I vividly recall a case early on in my career as a trial judge, listening to a witness and realizing that I was doing my best to make myself believe him, although his evidence was plainly inconsistent with contemporary documents. I then realized that this was because his mannerisms and appearance reminded me of my father. So heaven knows what other subconscious forces are at work in one's mind. Turning then from factual evidence to expert evidence. But sorry, I've turned over 2 pages. You'd helped me get to the end earlier, that would have been a relief. I want to make a wider point about the arbitrator's role in this connection. And it was a point concentrated on by Lucy Reed in her lecture, where she identified certain biases and similar subconscious features which justify questioning the reliability of arbitral or judicial or indeed any decisions, or to be more positive, factors which any conscientious arbitrator or judge should be aware of and trying to allow for. She didn't include beware of witnesses who remind you of your father, but I'm sure she would have done. But more seriously, they include things such as the anchoring effect, which effectively means that arbitrators should avoid being influenced by an initial fact which is in their minds from the start. In particular, when carrying out a quantification, arbitrators should ensure that they're not being influenced by a figure which has been in their mind from the start, sometimes for a wholly random reason. Then there's hindsight bias. Arbitrators should resist the temptation of hindsight. Of course, that's particularly important in causation issues or claims in negligence. Most of us exaggerate our ability to have predicted an event once it's happened. And so an event may seem inevitable or at least foreseeable now it has happened. I might add to that there's a danger that consciousness of this risk can mean that one leans over backwards so that one almost becomes too forgiving of someone who didn't see what was going to happen. She also identified egocentric bias, which means one should avoid relying on preconceptions. And we should make sure that we're not subconsciously searching in the material, in the case, for confirmation of our preoccupations. There's culture cognitive bias, which is very much of the moment. It's a controversial and difficult area, and at the moment the research into it, as Lucy said, is not very well advanced. And finally, there is something called extremeness aversion, which means that arbitrators and judges should not be unduly influenced by the tendency to compromise, to go down the middle in a valuation case, for example. A 2001 study of over 4,000 arbitration awards suggests that although there could well be a problem about extremeness aversion, arbitrators are less susceptible to it than is generally supposed. And of course, sometimes going down the middle is the right thing to do. 2 other features raise particular difficulties: intuition and common sense. Both are important factors in a decision-maker's armory, but both can be dangerous. It's not only that people may disagree as to the intuitive or common sense answer. As to intuition, all I can usefully say is that some people have better intuition than others, but nobody's intuition is by any means always right. As to common sense, particularly in the common law world, it's quite frequently invoked by judges and arbitrators. Although there are undoubtedly times when relying on common sense can be justified, I'd suggest that we should all be very careful of invoking common sense simply because it's a sign that we can't think of any other basis or
wish to justify the conclusion we want to reach. Sometimes the reason that we can't find any other good reason for our conclusion is because that conclusion is wrong. Particularly on a point of law, the right answer may not accord with common sense in a particular case, as common sense is not an infallible guide. And while points of law should result in a common sense answer, legal principles are applicable across the board, and inevitably on a particular strange or unusual state of collection of facts, they can lead to an unfair result. Much of what I've said about witnesses and arbitral biases apply to expert witnesses, but there are one or two further points worth making about them. The constant messaging from almost every judge and every arbitrator when it comes to expert evidence is that expert witnesses should tell the truth and should bear in mind that their duty is to the court or the tribunal, not to the party who's paying them. And that duty involves giving the experts honest view. It's an easy principle to state, it's an easy principle to understand, but it appears to be very hard indeed to comply with. And to be fair, it's not hard to understand why. Party-appointed experts are paid by the relevant party. They often attend conferences with the relevant party's legal team who discuss how to win the case. Their reports are analysed with a view to improving them in that party's interest, but nonetheless they are required to remain utterly impartial and to give their views accordingly. I have the honour of being the president of the Academy of Experts, and probably our main function is to drill the basic principle into our members' heads, but we still have to consider a fair number every year of judgments and awards which continue to be given, in which expert witnesses are criticised for partiality. Let me offer three thoughts about this problem. First, tempting though it is in many cases where it's possible, for instance valuation cases, as I've mentioned already, arbitrators should be very chary of splitting the difference or going down the middle. The message it sends to an expert witness is that I could well be harming my client by being honest. If, for instance, a purchaser's expert witness is honest and the seller's witness gives a biased higher figure than he should, going down the middle will reward bias and punish honesty. In other words, this aspect of expert evidence makes it particularly important for a tribunal to avoid extremeness aversion. Secondly, the problem with expert evidence could be solved by what is sometimes known as a pendulum arbitration or a flip-flop arbitration. This involves the arbitrators having to accept one figure or the other figure provided by the experts. In other words, the arbitrator decides on the right figure in his or her mind and then considers whether that figure is nearer the claimant's expert figure or the respondent's expert figure, and who's ever got closer, that is the arbitrator's decision. I would have thought that that would concentrate the mind of the experts and indeed of the parties, and would ensure that each of them put forward realistic figures. It would also improve the prospects of settlement, and if the case does not settle, it would also avoid the risk of extremeness aversion on the part of the tribunal. When I was in practice at the bar, I was involved in many valuation arbitrations, and I often suggested to clients that they should consider agreeing that the forthcoming arbitration should be on a flip-flop basis. As far as I'm aware, the suggestion was never adopted, so I suspect that making this suggestion this evening is unlikely to lead to any change in practice. My third thought, which is not meant entirely seriously, involves raising the possibility that maybe we have it all wrong and should give up trying to achieve the impossible, namely ensuring that expert witnesses give unbiased evidence. Instead, we should face up to reality and accept that expert witnesses can be as biased as they like. This would at least arguably help to ensure a more level playing field, as well as according more with human nature. But I think it would also have serious problems, as the tribunal could not rely on its view that any particular witness was honest as any sort of guide, although that may not be much of a problem, as some may think in light of human fallibility when it comes to assessing honesty. A different aspect of expert evidence was discussed by Donald Donovan in his lecture. As he pointed out, most maybe all arbitration laws and rules are not prescriptive as to how arbitral tribunals resolve issues of law, and he expressed the view that arguments on questions of foreign law should ideally be presented as submissions by the parties' legal representatives, sometimes by foreign lawyers, rather than by expert testimony through expert legal witnesses. He made the point that the arbitrator should be skilled at making decisions on law and applying legal reasoning, and since it would be better for them to engage vigorously, directly with parties' advocates on law, rather than having the tedious business of them being cross-examined as witnesses. I entirely agree, and I note that in his lecture, James Spiegelman described the use of expert evidence as the mechanism for informing the court of foreign law as generally inadequate. Partly reflecting the quaint, if well-established common law, notion that a tribunal's findings as to foreign law are findings of fact, and partly reflecting the notion that arbitrators don't have the ability to evaluate foreign law themselves, foreign law issues are traditionally the subject of expert evidence in common law cases. So each side calls a foreign lawyer who produces a report as to his or her view of the foreign law and is then cross-examined by the opposing counsel, just like any other expert witness. This is slow, clunky, and more obscurantist when compared with the natural course of the foreign lawyers making submissions on behalf of the parties and being cross-examined by the court or quizzed by the court. A lawyer making submissions is not committed to the legal propositions which they raise in the same way as a lawyer who is stating their expert view of the law. Cross-examination of a lawyer is not so much a testing of their views as an attempt to undermine their views, and therefore it turns into a battle where neither party is concerned with the right outcome, each is concerned to win. An arbitrator who engages with a lawyer does so with a view to testing the lawyer's submissions and seeking the right answer. And if cross-examination of foreign law experts is such a good idea, why don't opposing counsel cross-examine each other rather than making submissions? As Donovan pointed out, many civil law jurisdictions involve foreign lawyers making oral or written submissions on foreign law rather than giving evidence. And that seems to me to be consistent also with the relatively new idea of concurrent evidence or hot tubbing, which involves reducing cross-examination and increasing the judicial involvement in the expert's evidence. Turning from witnesses, I don't have much to say about hearings, which in my experience have generally been conducted fairly and efficiently. I have to say that because Michael Moser, who's in the audience, is chairing a tribunal I'm sitting on at the moment. Nor do I have much to say about closing submissions, whether oral at the end of the case, oral at a later date, post-hearing written briefs, or a combination of some or all. Indeed, I would say that it's sensible to agree a provisional arrangement in advance, not least because it's obviously desirable to fix a date for later oral submissions well ahead of time, but actually to leave the determination of the appropriate form towards the close of the hearing, as events during the hearing may well influence how the tribunal will be most assisted in terms of the manner in which closing submissions are made. Turning to the award itself, there are two principal points which I would like to make, one stylistic and the other substantive. The stylistic point is a plea that arbitrators should keep their awards as short as they reasonably can. Generally speaking, arbitral awards, like UK court judgments, are getting longer and longer, and there's no need for this. Clarity and concision are not inconsistent with thoroughness and fairness. Just as arbitrators do not welcome over-lengthy written submissions, so they should bear in mind parties do not generally welcome very lengthy, over-elaborate awards. And it might be said, the longer your award, the more room there is for inconsistency or self-contradictoriness, and the more words you have, the more room there is for the parties to find a ground of appeal. I note the Mauritius Mark rules provide that a tribunal may state its reasons as succinctly as possible without any need to restate the procedural history of the arbitration or the parties' submissions save to the extent necessary for such reasons, may state its reasons as succinctly as possible. It's tempting to suggest that the word may could usefully be replaced by the word should. As to the substantive point I wish to make, while they should avoid, of course, being rash or unfair, arbitrators should be brave. Like honesty and truth, justice eschews cowardice and requires fearlessness. There's always been a need for fearlessness in tribunals because arbitrators have a duty to apply and uphold the law, and failure to do so will lead to an undermining of public confidence in arbitration. But the growth of investor-state arbitrations and other arbitrations involving large claims against states and state bodies has resulted in what Robert Spano referred to in his lecture as arbitral tribunals having increasingly to reconcile conflicting interests of the protected investor and the public interest invoked by national authorities. And that requires particularly fearlessness. Let me give 3 examples where fearlessness is called for. First, tribunals should not be frightened about dealing robustly with challenges to their jurisdiction. That was a topic addressed in Bernard Riggs's penetrating analysis of law in his lecture on competence. In the UK and other jurisdictions, a wide scope has been given to arbitration clauses on the understandable assumption that, to put it simply, the parties must have intended all their disputes relating to their relationship to be dealt with by one tribunal. And that is a good message, I think, to bear in mind. Secondly, as pointed out by Yves Fortier in his lecture, tribunals should not be scared of concluding and stating that there's been corruption where it is alleged and established. There have been cases where tribunals have shied away from finding corruption when, in the light of the evidence, they owed it to the parties, indeed to the rule of law, to find it established. In a world where corruption and other criminality are increasingly perceived problems, those responsible for the rule of law, and that includes tribunals, should not be unduly reluctant from calling it out when they see it, as the judge did in the Nigeria and Process Industrial case, where, to be fair to the tribunal, he had evidence which was not available to the tribunal. The third point is also exemplified by the Nigeria case, where the tribunal accepted the claimant's expert evidence and awarded a massive sum of over $6.5 billion US dollars in favour of the claimant against Nigeria. This was despite a number of factors which, although Nigeria failed to raise them, were known to the tribunal and which could have significantly reduced that award. In my view, particularly when it comes to damages, issues such as damages based on a DCF calculation, tribunals must be ready to take a critical view of some pieces of evidence, even in cases where that evidence is not challenged by a party or is ineffectually challenged by a party. Indeed, perhaps particularly in such cases. Of course, where such a course is taken, a tribunal should ensure that any points of concern are put to the witnesses for the claimant or to counsel. I was going to turn finally to deal with a broader topic, namely that of confidentiality. But I rather think I've gone on long enough. I hope that I've identified some aspects of arbitration which are worth looking at, some which could be improved, and some which are probably unavoidable. What I failed to do is to identify the perfect arbitration system as signally as King Arthur's knights failed to find the Holy Grail. However, I hope I can take some comfort from the words of that preeminent arbitrator, commercial judge and writer, Michael Mustel, who wrote, "The world of arbitration is a fascinating mosaic. Lines of fracture run everywhere. Theory and practice, international and domestic, status and contract, civilian and common law, court-free and court-related, factual and legal, ritualistic and freewheeling, macro and micro, expert and legal. The opportunities for a broad conspectus, a unifying study, seem irresistible, yet they have been resisted. Perhaps because practice seems mundane to the scholar, while the theory is too rarefied for the practitioner, and perhaps also because the logistical difficulties are a powerful deterrent. With respect to Lord Mustel, I think it's a more human reason than that. I think that there's no such thing as a perfect arbitration, because there are so many different factors involved in arbitration, and the facts of each case, and indeed the personalities involved in each case, are such that there's no conceivable possibility of one size fits all. Thank you very much indeed.
Thank you, David, for that tour de force. David's kindly agreed to take questions, if anyone has any questions. Has anyone got any questions, or shall I kick off? Okay. Are you mic'd up?
I hope so, if I can be heard. If you're going to ask me a question, perhaps I'd rather not be heard, but I'll take it.
I just wanted to ask you what you thought about, go back to disclosure of documents. I mean, is there any less justice in the civil law system where they don't have disclosure to the extent that we do in the common law? And if so, isn't that a very good reason for changing the way we deal with documents?
There's undoubtedly a powerful argument for adopting the civil law system, but the truth is arbitration is very much party-driven, and if both parties want to have a common law type disclosure system, a full discovery system like the US, a more limited disclosure system like the UK, or an familiar arbitration system which is more limited but nonetheless has substantial amount of potential production, then they have to have what they want. And I think that the arbitrators should not be entitled to prevent them from that. But I do think that one way of dealing with that is for the arbitral institutions to lay down rules, either giving the arbitrators power, so when the parties agree to abide by the rules of the XYZ court, they are in fact giving the arbitrators power to cut down disclosure. But I think unless it's part of the deal, you shouldn't be able to impose it on the parties. As I say, they can either impose it on themselves by agreement or indirectly via the rules of the organisation who they agree to be bound by. But I think it's a choice which I can understand why people want it, but I'm sceptical that it often makes any difference, as I said.
Well, let's try and get some empirical evidence. Hands up anyone has had a case where there was a smoking gun. So there's your evidence. Is it worth it?
Perhaps there are a few people who can't remember. I remember what I said about witnesses.
Yes.
But no, that does slightly confirm what you think and what I think. But I think it would require massive culture, and as is said in that book by Charles Hollander, who's dealing with it in the context of litigation. Parties want it. That's one of the points he makes. And one of the differences between litigation and arbitration is that if both parties want something, it's quite difficult as a matter of principle, and for the future attraction of arbitration to deny it to them. But it's partly a matter of what people expect and culture. And if the courts change their ways, in the UK and in Hong Kong and in Singapore and in the United States, it may be that arbitration would follow.
Right. Anyone else got a question? No? No? Chan?
Do I have a question?
Question or an answer?
I have, no.
No. Right. Well, I'm going to ask Chan to say a few closing words, but before she does, I just want to remind you all that the ICA Congress will be here in Hong Kong in early May next year, and I hope you've all got it in your diary. We really want to put on the best show ever, and we're doing our best to arrange that, but of course we can't do that unless we get lots of people attending, and we need to get lots of people attending from our home base. So please make every advantage of the early bird registration, which I think is still end of the month, so we've got a couple of weeks left, and we hope that we'll see you all in May next year at ICA. So I'm now going to ask Chan to wish you a happy Diwali.
Has seen my henna, so happy Diwali to all of you. But wearing my Bickle hat, thank you very much for coming today. I will make just two brief closing remarks, and the first one is thank you very much, Lord Neuberger, for presiding over Bickle and its board of trustees, of which I am a member. We are in the process of a great transition with a new chair, and we are very excited about our future. And the second one is thank you for all of your support in Asia, and in particular in Hong Kong over the years. We started a few years ago with great support and great initiative sponsored by several of the law firms here, including Freshfields, A&O, Herbert Smith, Three Hills, and a few others who joined us in launching our Asia branch just a few years ago. So thank you very much for all your support over the years, and lots to come in the future. Thank you very much.